BOP 1 document showing that no record was found for the defendant having a license. We believe that that document was prepared in anticipation of litigation and to prove a fact at trial that he had no license, even though the document says no record. No record, in my view, is the functional equivalent of stating you don't have a license. And for that reason, it was testimonial hearsay in violation of the Confrontation Clause. This case has, in my view, some elements that are similar to Commonwealth versus Royal, but then there's also some elements of this case that are similar to what the Supreme Court of the United States decided in Melendez-Diaz, in that a drug certificate was prepared for no other reason than for litigation, and therefore to prove a fact at trial, which was that the substance was,
well, the drug certificates are prepared by people.
I'm sorry, Judge.
The drug certificates are prepared by people, right?
Drug certificates? They're prepared by the analyst, I'm assuming, who does the spectrographic analysis.
This is not a case that involves a computer-stored record that was completed, that was done by a person. It was a computer-generated record.
Well,
is that still a statement?
I don't believe it's a computer-generated statement, because Royal and Commonwealth v. Davis both say that a computer-generated record has no human involvement at all in its preparation. The CJIS documents with all the license to carry firearms in it, that's almost completely generated by people. It's the local police departments who put that information into the MERIC system, and then that goes automatically into the CJIS database. So it is not a computer-generated, in my view, a computer-generated document, because it has some, actually a lot of human involvement in putting the stuff into the system. So I believe it's not a computer-generated document. It's a computer document that has information in it, and then you take the information out of it. In this case, there was a search, and the search said, no record found, which to me is just another way of saying this man has no license to carry a firearm. To me, it's one and the same thing. For example, in Commonwealth versus Royal, the court said registry documents, registry of motor vehicle documents are business records because they're kept in the normal course of business and they're not produced in anticipation of litigation. So there's no testimonial hearsay problem, no confrontation clause problem with that kind of a document. And that case was decided, was reversed because they said it was a trooper who testified that the defendant's license was suspended, and he got that from the registry documents, and his statement was hearsay. But what we have here, I believe, is just another step that the person who testified, Mr. Dowd, I believe his name was, not only was what he was saying hearsay, but he was testifying because he had no personal knowledge of whether or not the defendant had a license to carry a firearm or not. All he knew was that he ran the records and it came back no record found, which again is just another way of saying you do not have a license. Okay. Another thing I'd like to bring up is that in Royale, the situation was that his license was suspended, okay? And in this case, if the defendant's license to carry a firearm had been suspended or revoked, that's the same thing, and the result would be the same in a criminal prosecution as never having gotten a license to carry firearms in the beginning. And so it's the same thing as saying, your driver's license is suspended. your LTC, license to carry, has been revoked. It's the same thing, and yet in the motor vehicle case, Royale, it came out being reversed. And in this case, we believe, for the same legal logic, the court should consider doing the same here.
So now that the non-existence of a license to carry is a required element, I'm sorry, now that non-existence of a license to carry is a required element of a 10A violation, how else can the Commonwealth prove that unless they do this kind, barring some kind of admission by the defendant?
Right.
How
right.
else can the Commonwealth actually prove the non-existence of this license to carry?
Well, I think,
for going into this database and determining that there are no hits?
Well, if you could have to call, well, I think you could do it by just calling the keeper of the records for the police department that arrested the defendant and ran the search, because two things are operative there. If he got a license through the Worcester police, or never got a license, they'd say, I'm the keeper of the records, I ran all our records here at the Worcester Police Department, and there's no record of this gentleman ever coming in and applying for a license, therefore he has no license. If the defendant applied for a license at some other town or city, and he moved to Worcester, he has a legal obligation under, I think it's 140, Section 129A, that you must notify not only the police department where you got the license, you must also notify the police department where you moved to.
Well, what's the difference between getting a keeper of records of the Worcester Police Department and Trooper Dowd, who effectively serves in some similar capacity for the entire decision system?
Well,
what's the difference there?
Let's just assume for the sake of argument that he did apply for a license at the Worcester Police Department and somebody forgot to put it in Merrick's. In other words, he does have a license. He thinks he has a right license, but the problem is somebody at the police department just didn't do the job correctly. Something fell through the cracks. Okay? I mean, would you want to put somebody a minimum mandatory 1-year incarceration because somebody goofed at the police station and didn't put your information in this CJIS system? Seems pretty draconian to me.
So I guess your argument goes to that you don't think that the search of the decision system is going to be sufficiently reliable to catch perhaps information that wasn't adequately, properly reported to the system?
Right.
Is that the concern?
Again, getting back to my argument that the BOP1 query is only produced in anticipation of litigation, and it's produced to prove a fact that the Commonwealth needs to prove in order to convict you of unlicensed possession of a firearm, and that's that you either don't have a license or you had a license, but it was revoked. Okay, so I think you would need to have the keeper of the records at the police department that arrested you and have them conduct a preliminary examination. And the prosecutor could also easily figure out, you know, if the defendant lives in this town now, he could figure out by doing some inquiry through the DA's office if he lives somewhere else in the last 30 days or you know, and if call that police department and say, this guy ever apply for a license? And if he said yes, he did, yeah, he did apply. Well, he didn't notify the Worcester Police Department that he had a change of address. But under the statute, there's an exception that we're not going to prosecute you and put you in jail for a year just because you forgot to put tell somebody that you moved. Okay, but for any other reason, like if the license was revoked because you committed a felony, or I had a client where his license was revoked because the chief of police thought he was mentally ill. He received information from a number of sources that the guy was not all there, and then he revoked his license. So what I'm saying is it's a better way. In other words, I would analogize the keeper of the records at the police department with the analyst at the state police crime lab that does the drug analysis, because that's the person that actually did the analysis, the whole 9 yards. Just as somebody at the police department, whether it was where the gentleman currently lives or before, did everything, filled out the application, did the fingerprints, did the whole 9 yards.
In this case, Trooper Dowd did actually conduct,
I'm sorry, Judge.
in this case, didn't Trooper Dowd actually do the search of the CG system?
He's, right, he works for CJIS. My understanding from the records, he's a retired state trooper.
It would be more advantageous for your client to have someone who has access to all of the documents, and all of the databases to do the search, rather than have one person from one local police department do it.
Well, because I think again, what if the police departments, you bring the person in from the police department and the police department says, oh my God, he does have a license, I just didn't put it in the system, okay? Mr. Dowd, or former Trooper Dowd, wouldn't know that.
But neither would someone from the local police department necessarily.
Well, if they searched their records, what if they came up with the application and they had the fingerprints and they had everything, but for some reason they just didn't get it into the American system properly? I mean, you want to go, again, you want to go right to the horse's mouth, so to speak, right from where it all began and say, you know, do you have records? And it's possible that he did have it. Or it was, or the chief revoked it, and you know, in a situation like that where it's been revoked, it's the same. It's that also, if that's what came up in the records, that would also be, in my view, testimonial hearsay because it's stating a fact that you need to prove at trial to satisfy your burden, the Commonwealth's burden.
So there's a case before the Supreme Judicial Court called Commonwealth versus Quentin Smith, and it was argued on March 3rd. It raises many of the issues that you were raising here with respect to confrontation clause and hearsay, and it also involves testimony by Trooper Dowd, coincidentally. I don't know if you're familiar with that case. Do you have any view as to whether we should...
I've heard that the case...
You've heard of the case, and so that we may well get some guidance from the Supreme Judicial Court in that case. I'm just curious if you have thoughts about that litigation versus this case. I'm
aware that the litigation is there and that the SJC hasn't come down with a decision, which is, as my brother rightfully put it in his brief, it's still an open question.
Yeah. Okay.
So, if there's no other, I'm sorry, Your Honor.
The question is whether or not, do you have a position as to whether or not this case should be stayed and we wait until the Supreme Judicial Court issues a decision in that case?
Well, that might not be a bad idea because ultimately whatever they come down with may affect how this court is going to decide the case. So perhaps that's a point well taken, Your Honor.
I'm taking it that you're ambivalent about whether that's the case or not, huh?
I'll leave it to your discretion, Judge. The other issue I raised was pretty straightforward. The gun that he was in possession of was a semi-automatic pistol. It was not a revolver. And a semi-automatic pistol, you can't tell it's loaded or not unless you pull the magazine out. Whereas a revolver, you can instantly tell if it's loaded or not just by looking at the back of the cylinder, and you'll see the cartridges.
So the Commonwealth says, well, there's two things here. One, he had it in his front pants pocket, and two, that there was some evidence of an altercation at the bar with a man named Joseph, and you put those two things together, that's enough to sort of establish a basis for finding knowledge. What's your response to that?
Well, if you're in a bar room and you put a firearm in somebody's face, that's pretty much all you need to do. I mean, you can't infer from that, by that action, that the person brandishing the firearm knows it's loaded. He just knows, I got a firearm, and if I hold up a gun that looks real and is real, nobody's going to say to me, well, you know what, I'm not going to listen to you because I don't think it's loaded.
But you have to couple that with he put it in his front pocket, and their inference, as we said in Resende, is common sense that one wouldn't put a gun in their pocket, in that case his waistband, if they didn't know whether it was loaded or not.
Well, all those firearms have, especially the semi-automatic, I know this because many, many years ago I worked at the Colt Firearms Factory in Hartford when I lived in Connecticut, and I used to make firearms. and I know how those firearms are made. They all have pretty foolproof safeties. So once you put the safety on, you really have to take
You don't think it's a common sense inference that one would not put a gun in their pocket without checking to see whether it was loaded or not?
I don't think so. I mean, a lot of people do. A lot of people who are not supposed to have guns put them in their pants pocket, and we know they're loaded.
Okay, thank you.
Just a case law. Thank you very much.
Mr. Crane.
Good morning, and may it please the court, Jesse Crane for the Commonwealth. The operative evidence here, the no records found, that was introduced both through Dowd's testimony and the BOP-FI printout, was non-hearsay for two reasons. The first being that it was computer generated. It was a function of Dowd's BOP-FI search. And I do think that distinguishes it from the Royal case, the fact that it came back with no records found rather than some sort of entry as did in Royal when the trooper searched for the defendant's licensure history. There the RMV had actually inputted some sort of record or statement to the effect that we have suspended the defendant's license. Here there was no statement put in by any licensing authority into Merck's or CJIS saying that the defendant has never been issued a license. It was the functional equivalent of silence. And that also, I think, leads into the second reason why it was non-hearsay, or I guess an exception under hearsay, which is that it was the absence of a public record. These firearms licenses are issued pursuant to a statutory authority by police departments. They are statutorily required to be maintained in Merck's. And so the fact that someone conducted a diligent search of the relevant database and retrieved no results makes the result of that search admissible under Mass Guide to Evidence, Section 80310.
So one complication here, you with appropriate candor mention in your brief, is that Trooper Dowd testified about the search he ran, correct? But the printout he brought to trial involved a query run by somebody else?
Yes.
First of all, why would that happen? It doesn't make any sense. And second, doesn't that kind of raise some concerns about whether the printout itself satisfies, I guess, at least authenticity requirements? Or, it's a very puzzling situation. So I don't know if you have thoughts about why that happened and what we should do about it.
Sure. So I don't think the record is crystal clear about why that printout was used as opposed to one reflecting that Phil Dowd was the person who had done the search. I do think, and again, this isn't in the record, so this is a little bit of maybe just the practicalities of discovery in district court. The prosecutor did say prior to the start of trial that he had just been informed that Phil Dowd would be the DCJIS employee who was actually going to testify. My educated guess is that the printout from Amy Conway, which is the one that was actually introduced, was what was given to the prosecutor ahead of trial and that he then provided to defense counsel through discovery. I think he maybe was in a little bit of a tough spot because he obviously had not handed over in discovery a printout from Phil Dowd, but he had functionally an identical document that had been run by someone else. And I think, I do understand the concern, but I do think it was sort of cabined a little bit the way it came into evidence. It was introduced explicitly as this was something I was given by my boss. We're introducing it just to provide essentially, this was the information that I ran when I did my search. And this result was consonant with the result that I received when I did my BOP-FI search. So, yes.
That may help your position. As you know, there was a important U.S. Supreme Court decision dealing with kind of similar issues, and there it was, I think, a drug-like person who testified about someone else's findings. That doesn't seem to be what happened here. Trooper Dowd testified about his own search of the
Yes.
own query and his own findings and right. But it does seem that if you can provide any guidance back to the police department, that it's really helpful to have the testifying witness present
Absolutely.
his or her own work product.
In other words, when Trooper Dow came in and said, I did this myself, he just could have brought his own paperwork with him, and that would have taken care of the problem.
I agree, and I fully recognize that that may be a better solution. I think just the reality of the way it unfolded in terms of who turned out to actually be testifying, that
To give Trooper Dowd a shout out, in this case, he did actually independently ascertain the name of the defendant and the date of birth through motor vehicle records, which is something that had not happened in the Quentin Smith case. So I suspect that that was something that was done intentionally, if I may ask.
yes, this was the same prosecutor as Quentin Smith. I think there was probably a lesson learned after that trial, and there was significant evidence about basically how the Commonwealth ascertained the defendant's birthday and the spelling of his name, which is an issue in Quentin Smith.
Just to follow up on that, do you have a view as to whether we should hold this case for the result of the SJC's decision in Smith?
I think Smith will certainly be helpful. This issue, the hearsay issue and confrontation issue, was squarely raised in Smith. The only distinction being in Smith, the BOP-5 printout actually wasn't introduced. It was solely the testimony of Dowd. But that said, I think there will probably be some very helpful guidance.
One of the issues that the court seemed interested in from watching the oral argument was the extent to which the trooper established the foundation for the reliability of the database. And I got to say, it seems like he did more in that case than he did here to sort of talk about how these records come into the system, how they're maintained, how they're updated, how we know that the database is reliable. We'll have to see what the SJC ultimately says about those issues, but it does go to the point that your brother raises about, well, how do we know this? How do we know this query is actually a reliable thing? And it does seem like there needs to be some kind of foundation put into the record about this is what the Merck's data or Decisions database does. This is why it's reliable. This is why we can count on a query producing reliable evidence as to the non-existence of the record. Do you agree with that?
I think the testimony here was broadly similar to what was in Quentin Smith. You again had Trooper Dowd testifying to the fact that an applicant submits his information with the police department. The police department enters it into Merck's review, or excuse me, the Firearms Record Bureau reviews it through Merck's, and then once all the checks are run through, the licensing authority issues the license, and the license is activated in Merck's. I do think it was a more cursory summary of that process here than in Smith. That's definitely true. Yeah. But I think the foundational, the necessary foundation was laid to establish that this is really the central repository for all firearm licensure in the Commonwealth. And Dowd did explain he had a significant career searching it. He understood how the database was populated, and he understood that these records were stored in that database, which I think is sufficient to provide at least that baseline to introduce his testimony. And if I could, I do just want to address one argument that my brother raised, that a town-by-town search would be somehow better. As I mentioned, I think Merck's is the better database to search because the licensing authority is required to enter all of that information in there, and it is centralized, and you do avoid a potential issue of saying, well, we don't know what town or city the defendant is a resident of. So we sort of sidestep some of those issues, the potential of missing a valid license by just looking at, say, the city of Worcester when the defendant lives in Shrewsbury and would have been issued a license by the Shrewsbury Chief of Police. I'll just quickly turn to the issue of whether the defendant knew that the firearm was loaded. The Resende case, I do think, is on all fours for this.
Maybe not so quick, because Resende is a bit different than your case, because in that case, there was evidence of the fact that the defendant had a firearm, and there was an altercation out outside of an apartment building.
Yes, and I think here we have similar evidence in the sense that the police, the officers testified to the fact that they were alerted to an altercation involving a firearm at the bar. The defendant had the firearm in his front pants pocket. There was also the claim that the defendant had been given the firearm by a friend named Evan. I think
That's the defendant's statement.
that was the defendant's statement, and I think from that statement, you could credit the idea that if someone is handing you a firearm, you might, at the very least, ask whether it's loaded. There was also testimony to the effect that the police officers needed to secure the firearm, suggesting potentially that the safety was off, although that was not explicitly stated.
Well, let me just back you up for a minute, because you say in your brief, while the placement of the firearm by the defendant in his front pants pocket is not enough on its own to prove the defendant's knowledge that the firearm was loaded, citing Grayson, and then you go on to the information that you think that from which we can rely on to infer that it was loaded to meet the Commonwealth's burden. So you would agree, I'm assuming, that if we found that the evidence that the victim came into the police station and reported an incident involving a firearm, of which we have no other information, if we were not to find that to be reliable or sufficient basis for an inference, then we would not be able to, it would be reversal with respect to the sufficiency of the evidence.
I would agree it would be a much steeper climb for us to argue, and I would just have to rely on the additional factors I mentioned to the extent that they're compelling.
I mean, the evidence of the altercation was pretty thin, right? It was one officer saying another officer told him that he heard there was an altercation at the bar, didn't really know much about it. The defendant gets asked, says, I wasn't in an altercation, but Joseph was at the bar and I met him, right? I mean, that's basically it, right? So it seems a lot, to Justice Vuono's point, it seems a lot less compelling than the situation in Resendez. Right?
I would agree that was the extent of the testimony, largely that there had been some sort of altercation.
Was it reported as an altercation involving a gun?
Yes, and I do think that is important. This wasn't simply like a fight. It was described as an altercation with a firearm.
I think the actual term was incident. Incident, but that doesn't matter. The victim did go to the police station at 1:30 in the morning, so one could also perhaps infer that it was something serious.
Yes, I would agree with that, and that would be the argument I rely on as to why Resende applies to this claim. If there are no further questions, I'm happy to rest on my brief.
Thank you. Thank you both. We'll take it
you.
under advisement. I want to thank our court staff, our court officers, my panel, especially Judge Vuono, who jumped in, the clerk's office, and our excellent timekeeper. With that, we'll be in recess.